Hello and welcome to the Minimum Competence episode for Monday, July 7th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover a rare Trump deportation trial, Apple's EU antitrust appeal, and looming cuts to legal aid that helped a domestic abuse survivor in Baltimore. Let's remember, forever is composed of nows, and read today's legal news. On this day in legal history, July 7th, 1898, President William McKinley signed the Newlands Resolution, formally annexing the Hawaiian Islands into the United States. Unlike traditional territorial expansion through treaties, this annexation occurred via a joint resolution of Congress, an unusual and legally contested mechanism. The resolution was named after Representative Francis Newlands of Nevada and passed by a narrow margin, reflecting deep divisions over imperialism, expansion, and national identity. Supporters argued that annexing Hawaii would bolster America's strategic and economic interests, particularly as the U.S. was engaged in the Spanish-American War and needed a naval base in the Pacific. The legality of annexation by joint resolution, as opposed to treaty ratification requiring a two-thirds Senate majority, sparked constitutional debate. Critics contended that this method sidestepped constitutional checks and amounted to imperial overreach. Native Hawaiians had overwhelmingly opposed annexation, as demonstrated in the Kūʻē Petitions signed by over 20,000 islanders. The resolution disregarded this opposition, cementing a colonial dynamic that would echo in future U.S. territorial acquisitions. The annexation also laid the groundwork for the eventual formation of the Territory of Hawaii in 1900 and its statehood in 1959, though not without continued controversy and calls for sovereignty. Legally, the Newlands Resolution exemplified the flexibility and limits of congressional authority in foreign affairs and territorial governance. It also introduced enduring questions about consent, self-determination, and the legitimacy of U.S. expansionism under constitutional law. This event highlights how domestic legal processes were used to justify international actions, revealing tensions between democratic ideals and imperial ambitions. A rare trial is beginning in Boston over a lawsuit challenging the Trump administration's policy of deporting international students and faculty involved in pro-Palestinian activism. The case was brought by academic groups, including the American Association of University Professors and the Middle East Studies Association. It centers on actions taken after Trump signed executive orders targeting non-citizens with so-called, quote, hateful ideology and promising to fight anti-Semitism. Plaintiffs allege that these directives led the state and Homeland Security departments to revoke visas and detain students like Columbia graduate Mahmoud Khalil and Tufts student Ramesa Ozturk, both of whom were targeted after expressing pro-Palestinian views. Unlike most Trump-era immigration cases, this one is proceeding to a full trial rather than being decided early by a judge. U.S. District Judge William Young emphasized that a trial is the best path to uncover the truth. Plaintiffs argue the policy violates the First Amendment, accusing the administration of suppressing political dissent on college campuses. The administration denies a deportation policy exists, claiming decisions are made based on security concerns, not ideology. Homeland Security officials insist the U.S. won't tolerate advocacy that they perceive as violent or anti-American. The trial outcome could shape how immigration authorities interpret and apply free speech protections to non-citizens in academic settings. It's only the second Trump-era policy case to reach trial under Judge Young, who has publicly criticized the judiciary for avoiding fact-finding through trials. Apple has formally appealed a €500 million or $587 million US fine imposed by the European Commission for allegedly violating the Digital Markets Act. The Commission found that Apple restricted app developers from directing users to more affordable options outside its App Store, which regulators said limited competition and consumer choice. Apple filed its lawsuit at Europe's second highest court on the last day allowed for appeal, arguing that the fine is excessive and that the EU is overreaching by trying to dictate how it operates its App Store. The company claims it altered its policies to comply with the DMA and to further avoid daily fines, which could amount to €50 million per day. Apple also contends that the Commission's demands are both confusing for developers and harmful to users. Despite the changes, EU regulators are still reviewing the company's new terms and have solicited feedback from app developers before deciding if additional enforcement is needed. The case is part of broader efforts by the EU to rein in the influence of major tech companies and ensure fair digital market practices under the newly implemented DMA. Maryland Legal Aid, or MDLA, a critical legal support system for low-income individuals, especially women and domestic violence survivors, is facing a potential funding crisis due to the Trump administration's 2026 budget proposal. The proposal includes $21 million to close out the Legal Services Corporation, or LSC, which provides federal funding to 130 nonprofit legal aid programs across the country, including MDLA. This move would eliminate a key source of support for clients like a Moroccan immigrant mother in Baltimore who received urgent legal help from MDLA while still hospitalized from domestic abuse. LSC-funded services assist people earning at or below 125% of the federal poverty line, a group that includes a significant portion of Baltimore residents, where 1 in 5 people live in poverty. MDLA, the largest legal aid provider in the state, operates 12 offices and assists hundreds of clients each week with issues like eviction defense, expungement, and protection from abuse. Despite receiving only 14% of its funding from LSC, losing this support would result in fewer clients being served at a time when demand is only growing. Staff at MDLA describe their work as essential, often likening their intake offices to emergency rooms. Without legal aid, tenants and abuse victims often face court alone without understanding their rights. Advocates say that legal aid services prevent homelessness, violence, and broader social harm. While similar efforts to cut LSC funding have failed in the past, the current budget process will determine if the latest proposals gain traction. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcription resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, that it will never come again is what makes life so sweet.